Hi everyone, this video is going to talk you through some drafting tips when preparing bonus and commission schemes. To start with, our advice is to ensure that the document relating to bonus and commission is set out separately from the contract of employment. This will ensure that you have greater flexibility to decide on the terms and, importantly, to amend them on an ongoing basis. Within the contract, you might want to specify that there is a scheme in place that an employee can participate in from time to time, but the terms should be set out separately. We should state that the scheme is non-contractual in nature, is discretionary, and that we reserve the right to vary, amend or revoke the terms at our discretion. In saying that, it's important to note that the courts have placed limitations on that exercise of discretion, so the general duty of reasonableness will apply, and there is also the implied duty to maintain trust and confidence in the relationship. That can be eroded if we make sweeping changes to reduce somebody's entitlement to nil, for example, to remove the scheme without notice entirely, or to make the targets unachievable in future years. To have the greatest power to amend the document on an ongoing basis, it shouldn't be static. And by that I mean we should be keeping that scheme under review every single year, tweaking the objectives, maybe even just redating the document to make it clear that we have applied our mind to the terms of the scheme and recommunicated those out. If we keep it static and the terms don't change for a number of years, the employee has more of an argument that there is an implied contractual right to participate in the scheme as it's drafted, and that does then limit our ability to vary the terms at our discretion. When looking at the criteria for the scheme, keep it objective as far as possible. That's very easy in cases with sales, for example, or revenue achieved or profit achieved, because that can often be determined in black and white, assuming we've drafted the definition of revenue and profit tightly. If there is an element of subjectivity, so it might require us to address our mind to measuring something that is more intangible, again, that has to be, or the forming of that opinion has to be exercised reasonably and in good faith. If we want to place more conditions on the entitlement to bonus, we have to be explicit in the document. So we've come across cases before where somebody's met a sales target or their team has met a net profit target, but the business wants to disallow bonus on the basis that the employee has, for example, a poor absence record, a disciplinary warning on file, or they might be in a performance process for problems that are outside of what they're being measured on in the bonus. But unless we are explicit in that scheme, in stating that a live warning, for example, will exclude them from participation in the bonus, our hands are tied in terms of having to pay that entitlement across to the employee. So if you want to place more conditions on earning the bonus, we have to be explicit. We should look at clawbacks as well. So again, in our experience, we've had circumstances where somebody's commission in one quarter has been based on a particular sales target. But what happens if there's a customer complaint? We have to make a refund, or we realise that the sale was never ultimately completed. You want to reserve the right to make a clawback in future months, or maybe offset any clawback against future entitlement. And we need flexibility during the course of any year or any period of operation of the bonus as well. So if, for example, somebody's targeted on a team profit or team performance, what happens if we increase the size of that team? If they've got to reach a certain level of revenue, but we've suddenly got more cost going in there, we want the flexibility to be able to amend those terms and make it clear that that target will be increased proportionately as a result. We need to define what triggers the bonus actually being payable. So if we're targeting someone on a sale, what is a sale, and are they the individual that's contributed to that? It might be clouded by things such as teleappointers or a team of salespeople working on a proposal. And when is a sale actually achieved? Is it when you've got a meeting with the client? Is it when they've signed on the dotted line? Is it when an invoice has been sent, or when it's being paid? Tightly define what the trigger is for actual achievement against the bonus. Conversely, if a target is based on net profit, what is net profit? What are we taking out as a cost of sale in order to calculate that? And for everything that we've said, that all of these areas will create some uncertainty or some room for manoeuvre in terms of an employee's argument. So the final point is to ensure that in your terms and in your bonus schemes, you make it clear that the board decision is final. So discretion ultimately rests with the directors to decide what an employee's level of entitlement is. I hope that whistle-stop tour of bonuses was helpful. If you do need some assistance in drafting these schemes yourself, then please do get in touch. Visit the website chadwicklawrence.co.uk for more information about our services, or email employmenthub@chadlaw.co.uk. Thank you.